Good afternoon, and you're watching KBN TV, the finest television in Zambia. Well, we are back again with one of your favorite TV shows, which is Labor Matters, a show where we get to talk about different issues to do with employers and employees. Make sure you sit in your living rooms and get informed on issues that you might be having questions about, and there's a number which is right on your TV screen if you have any questions and contributions about a topic of discussion for today. So today we are looking at a very interesting topic, I must make mention, which is a summary dismissal. And I know you have a lot of questions. You're asking yourselves, what is summary dismissal? What is it all about? So please do make use of the number which is right on your TV screen and send your comments and contributions about our topic of discussion for today. Well, so I am joined by Mr. Stanford. Good afternoon.
Good afternoon. All right.
I'm okay. How are you, sir?
I'm fine, thank you.
All right. So maybe wondering again, like, where is Mr. Kabanda? He's going to be right with us in the studio soon. Just please don't move an inch, as we have a lot of things lined up for you, our dear viewers, pertaining issues to do with employers and employees. Well, so the previous weeks we looked at a number of issues. So I believe we can have a little recap of what was discussed in the last episodes of Labor Matters. So one of the issues which was looked at was maternity leave. And can we just have a little recap of what maternity leave is all about?
Thank you so much. Maternity leave is a leave which is provided for in our laws for our mothers when they deliver. So I should think Mr. Kabanda explained in details the conditions that are supposed to be met and what an employee, that's a female employee, is supposed to do before one can proceed on maternity leave, and then also the obligations of the employers, because it's one of the topical issues where maybe people would want to limit the period within which employees can proceed on maternity leave. So these benefits or this kind of leave is well protected under our statutes, and we are encouraging employers that they need to acquaint themselves with the provisions of the law, and that even employees should also learn to appreciate what is there so that they are able to stand and protect their rights.
Right, so is there a difference between maternity leave and paternity leave?
Yes, there is. Maternity leave relates to our mothers, while paternity leave relates to the male employees. And one interesting thing which points to the difference, it's a period within which one qualifies for the leave. You would note that under our statutes, maternity leave, you need to take it every after 2 years after you've taken the maternity leave. But for paternity leave, interestingly, every year you can take it. How? I think those are some of the questions that actually arise, where people are questioning how is it that for the male employees they can proceed on paternity every after 1 year, but the qualifying factors are similar in nature. You would see that there should be a child who is born, and the parent should be linked to the child that has been born, and then we need to produce the medical report that indicates that the child has been born.
So do we have any implications when it comes to maternity and paternity leave?
Yes, we have some implications on maternity and paternity, and some of the implications that have come through, which are quite interesting, is that you would note that we have I might say we have about 3 different categories of employees who would qualify for either maternity or paternity leave. So we have the first category. You have an employee, say a female employee or a male employee, who registers a spouse with the employer, and then comes and says, okay, I want to proceed on a paternity leave or maternity leave. when you look at the provisions of the law, you are only interested in seeing that the actual employee appears on a birth record, not the mother, not the father.
But the actual employee.
The actual employee. So in an event that an employee comes through to seek for leave, and then either the mother or the father who appears on the birth record is not one who is registered, you see that the implications that the employer, yes, might be tempted to want to question, but the law is so silent that it seems we are restricted, as employers cannot go ahead and start asking questions.
Wow. So any implications for an employee registering a child born from a husband or wife other than a co-worker spouse? Yes.
The implications that are there is that, one, but we may just need to look at the rights that the employee will still have, what still accrues, even if such a situation happened. So I would look at a person who brings a child, and then the mother or the father is not registered with the employer. Mm-hmm. The implications that the employer has got limited way of resisting that. So the employer just has to register and allow the employee to proceed. Then we have situations where you have employed two employees and they've decided, they've fallen in love and they've gotten married, which is okay. And in certain institutions, they've even come up with policies in order to manage such situations. But it becomes so interesting where but it could be common for men, where a man would come forth and register as a child, and then the co-worker spouse is not aware. Mm-hmm. So the implications that, one, we have issues to do with confidentiality. So the employer cannot disclose to the spouse who hasn't been informed that your husband actually has registered a child which was not born from you. So that is one of the implications. And that even if the spouse had taken some steps to move and wanting to get information, it seems employers would be somehow restricted in disclosing the information because of certain principles which we have within the employment code relating to the taking of paternity leave.
All right. So do we have any remedy if the employer discloses the information to the spouse?
Yes. Internally, most of the employers, and if we review the employment code, maybe as we'll be moving into the program with Mr. Kabanda on this same program, we'll look at some of the procedure that we need to have. Employers are supposed to have a grievance procedure in an institution, and an employee who is aggrieved with what has happened, could be the disclosure that had registered a child and then I've noted that now you've started disclosing information, they can raise an issue internally through a grievance procedure.
All right, so that's quite an insightful scenario. Thank you very much for that.
Thank you.
So we are still talking about issues to do with paternity and maternity leave here on matters of employees and employers. So today's topic, we are looking at summary dismissal. We're going to go on a short break. When we come back as we start talking about summary dismissal. Stay tuned.
Hello there, my name is Enoch Piri. Catch Sports Extra on KBN TV, the finest television, every Monday from 18 hours to 19 hours. Every Zambian desires equality, development, freedom of expression, democracy, and access to basic needs. To achieve these aspirations, citizens anchor their hopes on political leaders. However, most of our leaders talk more than they deliver. Catch the analysis on KBN TV for in-depth, balanced, and blunt views. Join me, Henry Wiseman-Zulu, with other media personalities as we analyze leadership and national matters every Sunday at 20:30 hours on your finest television, KBN TV.
But beve bakuru batenga mamaini, bagulisa sugilite, bagulisa manganizi.
Can't even blame the millers. They've been told to go into business. Blame HH.
We will hold against them is the way they've handled.
That ministry has totally collapsed. There are no medicines in hospitals, there are no reagents, there is nothing that is happening.
This is State of the Nation on KBN TV.
Welcome back. You're still watching Labour Matters on KBN TV, channel 279 GSTV, 102 Top Star, and 27 on the Go TV, and also live on our Facebook page, which is KBN TV. Well, we're looking at paternity and maternity leave, and thank you very much for clarifying this too. I believe our viewers had a lot of questions, but with your clarifications, they have come to terms to understand what the two are all about. As I promised, I said Mr. Kabanda will be back, will be with us in the studios, and well, he's here. Good afternoon.
Good afternoon.
Welcome.
Thank you so much.
How is it doing?
Great. Glad to be here.
All right. So we're now going to dive into our topic of discussion of today, which is
Summary dismissal.
what is it all about?
I'll ask my colleague Stan to actually take you through the...
You don't take us through?
The definition part, I want him to take it.
All right, you can take it up.
Okay, thank you, Mr. Kabanda. Welcome.
Thank you so much.
Yes. Okay, yeah. Summary dismissal. Maybe before we actually move into the actual definition, we may want to understand the forms in which a contract of employment may come to an end.
Yes.
So, basically, there are only two ways in which a contract of employment may come to an end. The first one is dismissal. The second one is termination. Dismissal is what is giving rise to the topic that we have today. There are now, sometimes we interchangeably use these two terms, dismissal and termination, but they are quite different. Dismissal would require that you take out a disciplinary action for a contract of employment to come to an end. While termination does not require, does not even involve any disciplinary issues. So we should agree that actually dismissal connects to the conduct of an employee. Termination does not involve the conduct of an employee. It should be other factors that are supposed to be considered. Now, there are forms of dismissals which we need to appreciate. We have the one we are discussing today, summary dismissal. We've got wrongful dismissal. We've got unfair dismissal. And then we have unlawful dismissal. So then when we are looking at now the way we terminate, we have mentioned the two, dismissal and termination, these are induced by the employer. Then we have another form of terminating a contract, which can be induced by the employee themselves, which is usually resignation. I guess there will be time when we are going to look at this as well in detail. And then the other classes of ending a contract of employment, we can say that based on the circumstances. These are issues to do with medical discharge, death, and redundancy. Something should have happened in order for you to say we have this form of terminating or ending the contract of employment.
Wow.
Yes.
So it's as you can see, it's important to appreciate, because we started the program looking at bringing in the people. So at some point, it's important for the employee and the employer to understand that this employment may come to an end at some point.
Yeah.
And so the manner in which that employment now ends is what is the thing we are looking at. And as Stan has indicated, there are all those forms in which the employer and the employee can separate. And so it's just important that when it comes to this aspect of summary dismissal, everything is done properly, because there are laws that guide how the summary dismissal should be used. And we are talking about this topic because it's one of those that a lot of companies, there's that joke that you hire or fire, so we just change the H with the F. So it's important that the viewers, more especially employees, understand the steps, their rights and their obligations, but also the employers, the HR practitioners, the supervisors, those entrepreneurs who have 1 or 2 or 3 people with them, how do they actually go about carrying out summary dismissal if they ever think of using that route of separating with an employee.
All right, so what does the employment code say about the grounds for summary dismissal?
So one of the things that need to be appreciated is that in Zambia, there's a history to these things, and it's important that we appreciate the history where we're coming from, even as we go into what now the new law has stipulated. And I'll ask my colleague actually to take us through the historical part in terms of what was happening when it comes to summary dismissals, and how you might not need to go through certain procedures as long as there was a provision in the contract and things of that nature.
Yes. So you would note that I think as we have always understood summary dismissal, Mr. Kabanda has actually indicated that that principle of hearing that somebody has just been fired. You maybe have an employee, you could be an entrepreneur, you've come through, you are a boss, you are everything, you make all the decisions. You come through and you find that something has not gone as you expected, then you just say, no, tomorrow do not report, I fired you. And that those things were common.
It usually happens, but it may sound funny and
yes.
like, but these things do happen.
Yes, but now this is why I think today we are discussing that if they're still happening, with the coming of the employment code, those things actually need to change. So we need to understand the grounds on which summary dismissal would come through. One, we should establish that there's a fundamental breach of the rules that are set. Now, when you look at what has come through right now, we need to establish. In the past, how do you establish? You could establish as an individual on your own. As the owner of an employee, you say, okay, I think what you've done is not what I thought you should do, and I'm not very happy. So I'm deciding that tomorrow I shouldn't report for work, and your employment has come to an end. And at some point, it wasn't so much of an issue following the procedure, because it was understood that even if we actually strictly adhere to the procedure, the fact that we've already found a reason to terminate or to dismiss you, we have actually the basis to do that. Now, the employment code under section 50 has outlined some factors which Mr. Kabanda is going to explain to us. Those factors or the grounds that have been set out actually have altered the way we need to handle disciplinary issues which may result into summary dismissal. In the past, we thought, yes, without notice. Even now, it still stands without notice. However, now, you must be given an opportunity to be heard before you are actually dismissed. Yes, there are some scenarios in which an employee may be summarily dismissed and then you may feel you don't need to follow through the procedure. That will be based on undisputed facts. An employee has stolen and the person comes to admit to you, yes, I'm the one who actually stole and the reasons are A, B, C, D. You may be excused from not hearing or not following the procedure. But ideally, and a good practice which we are actually advising the employers is that sometimes employees may admit to those allegations. We may not know the circumstances in which they were admitting. So the best is, even when you talk to an employee and they do not dispute and admit to the facts, it will still be best that you go through the whole due process, and then at the end of it all, that's when you determine whether the charge actually would result into a summary dismissal. So right now, what has changed, moving from the past, is that we have to go through the due process, and that the notice issue only arises after you've established that the person indeed is guilty. And establishing is another topic that we need to have an impartial tribunal which is set up in order to listen to the employee and the charging officer. Yes.
Mr. Kabanda.
Yes, sir, definitely. Thank you so much, Stan. So one thing to clearly understand, and like you said, there is a history to these things. And so in the past while, you could, as long as you could prove that indeed this person has done this, you would fire them. It is important to understand that those things are now a thing of the past. So just as we said, and we will take it back a little bit, when you are employing, so if you are an HR person, you're a supervisor, or you're an entrepreneur, and you are recruiting people, one of the things we advise, the first thing to start with is, please make the rules of the company to be very clear to the employees. You sit down, sometimes there's a lot of pressure, and this happens even in big companies, because HR is recruiting the department that is supposed to receive somebody. They basically say, oh no, just bring that person, we are behind schedule. Yeah. So yes. No, what we're saying is that from the very beginning, sit down with the employee and do what is called induction. During that induction, and the induction is just, oh, welcome to company X. It is supposed to take the employee through everything. What is this company all about? Why was it set up? What are we trying to achieve as an institution? And then this department or the section where this person will be, then the job of this person, what exactly will be their role? The person needs to understand clearly what their job entails. Because in that way now, you are now helping the person to understand the standards, the rules, and all policies of the company. What that does is that it forms a basis, and we normally advise, and if a business is starting and they don't have those things in place, they can always follow up with the consultants or their lawyers. They need to now have a form even, where the employee signs that I have been taught or have been trained on this. So the employee knows the rules and the standards. Why are we talking about that? It's because when you look at what Stan was talking about, the employee now can be summarily dismissed on two things: the employee's conduct, or the conduct, or that's behavior, or their performance. So I usually like to call it BP, like the filling station, behavior and performance. So for these two things, you as an employer, you're an entrepreneur, you're a business owner, you're a HR, you're a supervisor, you need to be in a space where you actually can demonstrate also that you brought these things to the attention of the employee. And the employee understood and they consented. There are two things. They need to understand and they consent that they are going to abide by the rules. It becomes very, very easy at a time of now trying to discipline the employee, because now you are saying, my friend, we told you here, don't get if you are into the business of mini meal, or you are doing fertilizer, or you are doing cement, or you are in a mine, we told you don't touch these things, or anything that does not belong to you belongs to the employer. So you have made those rules clear, and the employee usually is required to actually sign. So that if in future they come and claim that, no, I didn't know about this, but even then, we need to make this very clear, because sometimes employees also want to say, no, but I was not told. No, if it's not yours, it's not yours. Whether you are told.
Not told.
No.
I wasn't. I was not told.
If you are found with something that is not yours, which belongs to the company, it matters less if you are told or not.
Yes.
But key to it is that as an employee, only be found with that which you should be found with. And these things we also emphasize because it affects what we are going to talk about. Even, because the first thing is, even when it comes to an instruction, if you are found doing something, or you have taken away something because somebody instructed you, no, even that instruction needs to be a lawful instruction. So if you know that you are getting something that belongs to the employer, and your foreman or your supervisor is telling you, no, just do this, you know this is not the right thing. So when now they catch you, it shouldn't be now, no, I didn't know. Instructions also need to be lawful. So we'll go through those key steps.
All right, so if you're just joining us, we're watching Labor Matters on KBN TV, and today we're looking at summary dismissal. If you have any comments, questions, or contributions, please do use the number which is right on your TV screen. Don't call in, just drop us a text message and we'll read it right here. So, are there some offenses that we can point out that may be penalized by summary dismissal? Mr. Stanford.
Yes, we have. Now, one interesting thing, as Mr. Kabanda was explaining about summary dismissal, which we shouldn't actually miss out, is that the common understanding of summary dismissal is that the moment you decide to commit an offense which might result into a summary dismissal, ideally you're actually applying that I want to leave the institution. So it's actually an application by an employee.
An indirect one.
An indirect one. So when the employer evokes the disciplinary process and takes you through the whole process and ultimately they tell you you should leave, and that's why there's even no notices, they are merely accepting that for what you did, which you knew you shouldn't have done, and you knew the consequences as you were inducted and you are told, and you have the rules, you're able to read through every time, you're able to remind yourself, but you've decided to do something else, we are accepting that you want to part company with us. So actually, you've already terminated the contract yourself. He gave an example of you taking out something. Imagine where you're working here and today you knock off and you find that you've gone out with the equipment. The cameras have gone. Then tomorrow the employer will be asking, say, where are they? No, I took them home. Either you start making arguments of no, because you haven't paid me, I've done that and everything. Then when they take you the whole process, they're just trying to merely accept that you wanted to leave. Now, what are some of the examples? Now, we get back to the employment code. The employment code has given us examples. So we have 3 categories which would be a basis for a summary dismissal. There are offenses or a kind of offenses that have been outlined in the employment code. Certain offenses are supposed to be outlined in the disciplinary rules, like Mr. Kabanda indicated. Then we also appreciate that we've got common law duties, all of us, which may not be mentioned to you that one, the employer, even you, as you are here, we are talking of the cameras. There's one expectation that these cameras are actually safe in your hands. And if tomorrow we discover that they're not there, you've breached that duty of trust. Because there's so much trust and that you're going to do that. And no one is going to tell you that, no, everything that has been left under you, we know that you are going to do that. So when we look at the employment code itself, which we are encouraged to look at section 50. Section 50 has given us examples. One, it says, where an employee is guilty of gross misconduct, inconsistent with the express or implied conditions of the contract of employment. Now, of interest is a guilt of gross misconduct. Guilt you need to establish. And that's why the issue of procedures is coming back. How do you confirm that an employee is actually guilty? Then guilt of what? A gross misconduct. If you review the employment code again, interestingly, the level or the extent to which a misconduct will amount to a summary dismissal also is not provided. And now we get back to what Mr. Kabanda said. Do we have the procedures in our institutions? As we are coming up with the companies, can we remember that we need to have procedures so that in your institution, you should be able to define what gross misconduct amounts to. And then it will be easier at the time that you take out a disciplinary action to know that this is what is there. The second one is willful disobedience to a lawful order given by the employer under subsection 1. He mentioned you are given an instruction. What kind of an instruction have you been given? If you disobey willfully, says willful disobedience of the order that has been given by the employer. Now, in this instance, the employer is not a person that maybe you met that day when you come through. Could be any person who is representing your employer, could be your supervisor. And when we are saying lawful order, it doesn't necessarily point to legal instructions that are there. Anything that does not contravene the company policies, public policy. If tomorrow you are told, no, when those people come for an interview, can you lock them up and can we have some poisonous gas and do it? If you don't do it, that's not a lawful order. You have the power to disobey that. So there are certain instructions that people are taught to take, and they're not supposed to do that. But of interest, which I think most people need to be aware of, is which is C. It says, for lack of skill, which the employee explicitly or implied is warranted to possess. But this is what we do. Now, it starts with the way we draft our resumes. Sometimes we actually just go there, you find somebody has got a CV. Okay, this person is a presenter. I think I know Madam Patricia. Let me just get the same CV that she's used. You just copy and paste and put that I'm able to do this and that. And when people they advertise and you present your CV, they are moved and think, oh, this person actually can do what we want. Yeah. You've already purported that you can do that work. If you fail to do that which you purport to be able to do, what is your employment? You can still be summarily dismissed. Now, all what we are discussing, yes, we've discovered that you can't do what you were purporting. We need to prove that you are guilty by following the due process. So we're not going to leave this aspect of the due process. Let's go back to establish what actually happened with this. And then you've got habitual absence. The common is terminology out there is desertion. Somebody deserted. But when you look at now, you look at what is written, habitual or substantial neglect of duty, then we have a continued absence from work without permission of the employer or reasonable excuse. Yeah, we'll discuss about the habitual, there's a substantial neglect, which is to do with poor performance, and Mr. Kabanda briefly talked about. But I'm interested in desertion. Desertion has actually left a lot of people without employment because they would think, in that company, somebody was only fired after 10 days. The other company is 15 days. In this other company is 5 days. We do not have a standard minimum number of days for which you'll be absent. So it's better for you to acquaint yourself with the rules that are in the company. You cannot be challenging your employer that, our colleagues in another institution, company B, them it's 15, us why is it 5? Yeah. Why is it 10? So it would vary according to the practice. So your attendance to work actually is one of the critical requirements in the employment. It shows that you are willing to work. The moment you presented yourself that you want to join this institution, you were indicating to the employer that I'm willing to perform the duties and I'll be coming. So when you stay back, actually you are showing some kind of disrespectfulness. That now, one, I don't care about what is happening at your institution, because you see what they have said. Say without reasonable excuse. So if you have reasonable excuse, that is not taken to be absence. If you have reasonable excuse, then communicate to the employer. If you stay back and you don't even communicate, there's some lack of respect, and it indicates that you're no longer willing to work. And an employer, if they decide to take action and it's established that you never came through, you can actually be dismissed. Those are some of the reasons, other than F, which points us to the disciplinary code, that other than what has been outlined here, certain grounds are also outlined in the disciplinary code. So what grounds have you put in the disciplinary code? Some employers have got codes that are not well crafted. So when they are faced with a situation, that's when they are wondering, say, what should we do? So we need to, one, come up with a document, share with the employees, and be able to remind the employees from now on going forward, so this is what we are going to be doing. And sometimes you might not notice that maybe employees, a particular trend, maybe it's absence, it's habitual neglect of duty. That's the time that you also need, maybe you engage your consultants or your HR department to move in and start now sensitizing employees that, we've noted that there's a habit of certain offenses repeating themselves, and we are concerned.
Right. Mr. Kabanda, there are some situations where employers, they just wake up and decide to, okay, I just want to fire Patricia today. I just want to fire her. Are there any right step that an employee has to take when it comes to summary dismissal?
Yes, so for employers, and this is one of the things we are really emphasizing, that please, the things of the past are the things of the past. Do not just wake up. And like what has been said already, the first thing, and let's look at two different groups of employers. Let's talk about the small, medium enterprises. This is the entrepreneur who's just started off. He has maybe 1 or 2 or 3 employees. One of the things we do advise, even for other companies that are formalized or businesses that are formalized, but they don't have maybe HR and so on, it is still important that they have a document called the disciplinary code. And again, if they cannot make that for themselves, they can go to consultants to help them to now set up the disciplinary code. Like what has been said, the key issue is that you can no longer just wake up and fire someone. So the disciplinary code then starts to stipulate exact steps that should be followed. Okay? So if you are a small business or you are a business that has not put in place a disciplinary code, again, this is something that is important, that the employer or the business owner, the HR in that company start to put those things in place. Now, for the bigger institutions, the aspect that we can also talk about is that they also need to ensure that they are checking that their disciplinary codes are also up to date. We have been to different companies and we find a disciplinary code which was there in 2000, 2002, but the laws have changed. So certain things that you provided for in the disciplinary code are no longer applicable. Where you simply indicated, like what Stan was saying earlier on, that if you are just found with something, you're fired with no case hearing, no nothing. Again, that disciplinary code is not in line with the law anymore. And that's why we are saying even bigger companies that have disciplinary codes, they need to sit down and check that their disciplinary codes are actually up to date and they're in line with the law. Now, for both the bigger companies and small companies, those that have the disciplinary code or the disciplinary codes have now been put in place, it's important that there is now teaching of the employees about these disciplinary procedures. And remember, in the disciplinary code, it will now stipulate, like what Stan was saying, there are certain things, certain cases you will not find in the employment code. But in the disciplinary code, you're going to put everything there, depending again. And again, this is the thing we also say, don't just go and pull something from another company. Because this, you found a guy who was working in a mine, is your friend, you take. You are a microfinance. Sometimes we are called to help some companies, and you are sitting there with a disciplinary code. You are finding the charge that they have raised is a charge that shouldn't be there because it is applicable in another company. So again, you cannot just pick a document and say, okay, we can also use this. Customize everything to the institution, to your business or to your company. And once that is done, train the employees. There are forms that they will be given to show that they have actually been trained, they understand the rules. And now, in terms of procedure, when an employee is suspected, and remember we are using the word suspected, to have committed an offense, you need to carry out, first of all, you suspect. That's step one. Then from there, you need to actually now carry out an investigation. Okay? Now, there are times that we are told, okay, look, I caught this person with with this property for the company. So for me, it's guilty. Mm-mm. Mm-mm. Even if you found a person with that item, you still cannot just fire them. Remember, so first of all, treat them as suspects. And then from there, do a thorough investigation, understand the situation. Because sometimes you could also make a decision very fast. You fire someone, but then there was even a syndicate. They were working as a group. So what have you done to yourself as a business? So that's why we always encourage investigations that are factual, because the evidence you are gathering as a business, that is, remember that anytime you're dealing with a case, your mind should be sitting in court. This is one thing we emphasize even during trainings. Your mind should be sitting in court. That is what helps you as a business, as an HR, as a supervisor, to make sure that you are not emotional. Because sometimes, no, I've suffered too much, I've been having losses. Get out of my face. What have you done? So avoid emotions.
Yeah.
Disciplinary matters are not a place for emotions. Because when you go to court, you'll be embarrassed. And these are the things that we see people now saying, no, I fired this person, they went to labor office, now labor office is making noise, this guy has bribed the labor office. What have they bribed? Who have they bribed? You simply didn't follow the procedures. Yeah. It's as simple as that. You go to court, you lose, the court is telling you now to pay damages, and you start now frowning, no, these people in court. No, the issue is suspect, number one, carry out an investigation, and if possible, what we encourage is independence. Okay, so that what you're gathering are facts, because what are the facts you can go and produce, the evidence you can even produce in court should this employee actually sue you. Once you establish this, then you charge the person. Now, when you raise a charge, you're giving them now an opportunity, first of all, to even write back to you and respond to the charges. When they respond, and based also on the evidence that you gathered, you're able now to see, is there a case? Because sometimes you find that after you look at all the evidence and the submission from the person, you find that really this was not the case. Sometimes even the charge that you wanted to raise, you find that it is supposed to be a different one, because maybe now they have also implicated other people in the whole thing. So it's important that you look at those things once you charge, the person responds, and once you have received their responses and you look at the evidence, then from there you can now determine if indeed this case can be dropped now. And I know when I say dropped, because sometimes even supervisors, sometimes they say, no, this can't be dropped. No, if the evidence is pointing to the fact that there's no issue here, drop the case. If you see that there is proper evidence that you have, now you can escalate the matter now, where the person can actually now end up in the disciplinary hearing. Now the disciplinary hearing is another level of giving an employee an opportunity to be heard. Remember,
such an interesting
it is an issue that needs to be very, very clear.
Sure. Maybe we can take 3 or 4 questions that we've received, because I believe time is running out.
Yes.
All right. So this one is saying, good afternoon, gentlemen. Oh, I'm also a gentleman. Yeah?
Yes. And lady.
Sure. I was dismissed from government 2 years ago, and I was not given time to be heard. I have since appealed to the reinstated, to be reinstated. Which other avenue should I use for my grievances?
Okay.
Well, I wish to thank you, Owen K. Kalamba in Stanford, for your tremendous help in our growth of HR in Zambia. Excellent work. I'm always left at the level of dedication and hard work you put in helping the HR field. May you reach. Okay? This
Thank
one
you.
is,
Thank you.
making me blush here. Thank you so much to our viewers for sending in these messages. Please don't call in, just text us. What can I do, because they dismissed me without any notice, and I have worked in this company for 2 years. What can I do? Please assist me. Well, good afternoon. What does summary dismissal? Good afternoon. Does summary dismissal has benefits of leave days? Maybe you can take these questions.
Okay. The interest of time. So what we'll do, like we've said before, we're working with Ministry of Labor. So when we receive concerns and complaints, we basically do forward those to the Ministry of Labour. So it's important for those that were summarily dismissed and the procedures, they do believe the procedure was not followed. Again, for the employee, it's also important that the employee understands these processes, and that's why we're talking about them, and also the employer understands. So if anybody was fired without the due process, it is for that person to put together, first of all, their contracts, any documentation that shows that they were working with this employer, put everything together. If there was any hearing, whatever it is that happened, any documentation you may have, put those things together, and then go to labor office in the district where you are or you are working, and then they should be able to then look into your case, and then they can then assist from there on. There are cases that may be escalated to court. Some cases could be resolved just at labor office level, and that's what we can encourage.
We also have an interesting question.
About if the
what
benefits?
is overtime determined? What is the lowest pay rate in line with labor matters? I think this.
So for overtime issues, I think that was the topic that we had in the last episode. So they can go to the KBN TV Facebook page. We had this session recorded live, I think 2 episodes ago. Otherwise, overtime, the law is also in the employment code.
Sure.
They should read under the section that talks about hours of work. There it stipulates what overtime will apply to an individual who works for more than 48 hours in a week, or whatever number of hours that are stipulated in the employee's contract.
This has been an interesting conversation, I must say. To our viewers, please do send us your text messages using the number that is right on your TV screen. As much as we might be offset, please, if you have the number, do send in your text messages. Mr. Stanford.
Yes.
As we get to the close of this interview, any last remarks to the viewers out there?
Okay, for me, I just want to emphasize what Mr. Kabanda had mentioned on us borrowing documents from another company. I want to mention that the gravity of the penalties actually would differ from one employer to another or from one industry to another. I'll give an example of sleeping on duty. You find that for people in the offices, sleeping on duty will not be as serious as a person who is monitoring maybe an equipment. It won't be as serious as a person who is working under security. So I'm encouraging employers as we are trying to come up with our small businesses, as we're expanding, as we're experiencing new modes of offenses. Yes, offenses could be almost the same, but the penalties are supposed to be checked that we are not just transplanting, and that the rules that we are coming also should be helping us to achieve our objectives. That's another thing. We shouldn't just have rules because in another company there's a disciplinary rule that says you shouldn't sleep on duty, but you don't even know how it helps you in your company. Then you end up having a document which is so big, and employees cannot understand, because most of the issues do not actually help out in achieving what you are doing. So ensure that the rules that you have a connection to your objectives, to your mission, to your values. There should be a link, so that when that rule is breached, you're able to say, I cannot survive without this. Thank you so much.
Mr. Kabanda.
Well, I think it's just to encourage employers to ensure, once again, to have everything in place. We'll see if we can have some more time in the coming episodes to break down, especially when it comes to these disciplinary codes, what should be in there. Because we have seen a lot of cases where you could actually end up losing a case even when you have a disciplinary code, because the way that document was crafted does not allow you room to actually maybe find an employee guilty properly. And so there's need for also the people who are dealing with the cases to also be trained. It's not to be excited now that like you're trying to kill someone. There should be order, there should be professionalism in terms of the way disciplinary cases are dealt with, even as you work towards summary dismissal. So I think we will try and expand more in the coming episodes, and we wish the viewers, employees and employers the best in their jobs.
Oh, thank you very much.
Thank you.
Well, you've been watching Labour Matters on KBN TV, channel 279 GSTV, 27 Go TV, 102 Top Star and live on our Facebook page, which is KBN TV. Well, today we had an interesting topic, which is a summary dismissal. Make sure if you're just joining us, you can go right on our Facebook page and get to watch what Mr. Kabanda and Mr. Stanford had to say about our topic of discussion for today. My name is Patricia Chilamika. Make sure you do tune in next week, same time, same place. Good afternoon.